Oh, come on!
Hey Legal Eagles, D. James Stone here teaching you how to think like a lawyer. Last week we covered the first half of Liar Liar. Today we're covering the second half, including the entire divorce trial. So let's dig in. Remember to like and subscribe, and be sure to comment in the form of an objection. I'll either sustain or overrule it. And while you're there, let me know what movie or TV show I should do next. And stick around until the end when I give Liar Liar a grade for legal realism. So without further ado, let's dig into the second half of Liar Liar. That is not what courtroom bathrooms look like. That is way too nice. Why are all these people in this court? This is a random family divorce. There's no reason all those people should be there.
From March 6 through June 12, I surveilled Mrs. Cole at the behest of Mr. Cole. During that period, I noted that Mr. Cole left each day between 7:40 and 7:50. Thereafter, Mrs. Cole would frequently have a male visitor arrive and stay from 1 to 4 hours.
So at this point, I think Fletcher Reed, Jim Carrey's character, should probably be objecting. There are a couple issues here. I don't know if they win the day, but they're probably worth objecting to. Number one, California has some really strong invasion of privacy laws. So this investigator is conceivably invading the privacy of Mrs. Cole, presumably what is going on in her own residence inside of her own bedroom. I don't know if that creates an evidentiary burden to bring this evidence in, and therefore it would be unlawful to bring this kind of evidence into their divorce proceedings. That doesn't seem like it would carry the day, because I'm sure that there are many instances of private investigators actually taking the stand and providing exactly this kind of evidence in a wedding proceeding to show adultery and a violation of the prenuptial agreement. But as a putatively experienced trial lawyer, Fletcher Reed really should be breaking up the flow to prevent the private detective from getting into a rhythm and getting his entire story out and showing all of presumably the bad evidence that's about to come out.
I was able to take several photographs of the male visitor.
I see.
I don't know what the attorney has just done here. She has handed the photographs from the witness to the judge without laying the foundation that's necessary. A photograph needs to have foundation laid before you can bring it into court, to bring it into evidence. And if you don't bring it into evidence, then it's as if the photograph never existed, because the judge can only take things into consideration that actually came into evidence. So she needs to lay the foundation that this person took those photographs, that they reflect the scene accurately when he took those photographs, and that they're a fair and accurate representation of what actually happened. So those are all evidentiary hurdles that this witness must establish and overcome in order for these pictures to be entered into evidence. And the attorney just can't pick them up and then hand them over to the judge. It doesn't happen. You slowly enter them into evidence after you've laid the appropriate foundation.
Your Honor, as you are aware, under the terms of the prenuptial agreement, if Mrs. Cole commits adultery, she is entitled to nothing. With your permission, we'd like to play the following tape recording.
No. Okay, so there are a lot of problems with what just happened in court. In order to establish that this witness has the personal knowledge of what happened between Mrs. Cole and her gentleman callers, the lawyer has to establish that he has some reason for this personal knowledge. In other words, he has some basis to be able to opine as to what was going on. And he actually took a step back and said the wrong thing, that he doesn't really have personal knowledge because they kept the shades drawn. So he doesn't have a visual confirmation of what was going on. What he does is that he heard what was going on behind closed doors. He was using some form of electronic surveillance to hear what was going on in the bedroom. Unless, of course, they were engaging in conduct so loudly that he was able to hear that without the aid of an electronic device. But let's assume for the moment that this is a fairly sophisticated private investigator and he's using electronic surveillance equipment. If that's the case, then he doesn't have personal knowledge except for what is on this videotape. Now, California not only has very strict invasion of privacy laws, but California also has very strict electronic surveillance laws. And California is a two-party consent state, which means you need to have consent from all of the parties to a conversation before you're allowed to electronically surveil them. So you can't just pick up the phone and start recording. You need to actually get consent from the other person that's on the line of that telephone. And electronically surveilling someone in their own house might be a violation of that electronic surveillance wiretapping law, which I think would really preclude this particular evidence. So Fletcher Reed really should have objected on multiple grounds right now to prevent this kind of testimony from coming in. It might be an invasion of privacy, it might be a violation of the Electronic Surveillance Act, and there's very little chance that Mrs. Cole consented to this recording. So those are all very good reasons by statute that this evidence might not come in.
Do it to me. Oh, do it to me. Harder, harder.
Oh, come on!
Okay, there's also a huge hearsay problem, and I just live for good hearsay questions. The tape itself is hearsay, and arguably, what is being said on this tape is also hearsay, so there is a double hearsay problem. Now, you can get over double hearsay by showing an exception or an exemption at both levels, but because there's hearsay in what's being said and hearsay in the form of the tape, you have to have an argument for both of those levels before testimony like this, evidence like this, can come in. So let's talk about the first level of hearsay in the tape itself. Now, just because you have a recording does not mean that it's not hearsay. On the contrary, it is still an out-of-court statement. A document can be hearsay, a videotape can be hearsay, and an audio tape like this can definitely be hearsay. So I think the easiest way to get around this hearsay problem is to establish from the private investigator that this is a business record. He is essentially in the business of creating audio tapes exactly like this, that he has done it many times before, and then lay the elements of the business records exception, that he is a custodian for this particular audio tape, if not the creator of this audio tape, and that it was formed in the regular course of business, and just go over the different grounds for the business records exception. So let's assume that he's able to get over the first level of hearsay in the audio tape itself. I think that there is a presumption that emails and actual recordings tend to be pretty reliable, so courts try to bend over backwards to get those kind of records in. So we get to the second layer of hearsay, and here's where it gets really interesting. You might say that what is going on in this tape, they're out-of-court statements, and therefore they should be considered hearsay and excludable from evidence. But remember that hearsay is not just any statement. It is a statement used to prove the truth of the matter asserted. Now, no one is using this tape for the veracity of what is actually being said on the tape. In other words, that her gentleman caller is actually better in bed than her husband, or that God exists because she keeps saying, oh God, oh God. Instead, what they are doing is showing the existence of the underlying acts. In other words, that she committed adultery, and these exclamations are evidence of engaging in that act, which has legal significance under the prenuptial agreement. So, I don't think this actually qualifies as hearsay, because hearsay must be a statement used for the truth of the matter asserted. They're not using it for the truth of the matter asserted, and therefore we don't even have to talk about whether it's an exception to the hearsay rule. I don't think it qualifies as hearsay in the first instance. Now, that being said, I think Fletcher Reed really should be objecting here, because he needs to break this up. He needs to try to prevent this tape from coming into evidence, and he's just allowed the other attorney to play it whenever she wants and establish its credibility. He might lose these hearsay objections because it probably gets in under the first level, and it's probably not even hearsay on the second level, but still, you gotta object. You've got to preserve the record to show that you objected so that you can make that argument on appeal, and you've got to break up the flow of the direct examination. Not good lawyering by Fletcher Reed here.
Your Honor, I object!
And why is that, Mr. Reed?
Because it's devastating to my case!
Overruled.
Good call!
Not a valid objection, and the judge was right to overrule it.
willing to grant me a short bathroom break?
Can it wait?
Yes, it can. But I've heard that if you hold it, you can damage the prostate gland, making it very difficult to get an erection or even become aroused.
Is that true?
It has to be.
Well, in that case, I better take a little break myself.
You know, I was going to object and say that this is a conversation that really should take place during a sidebar, but then it occurred to me that there is no jury, so there's no reason to have a sidebar. A sidebar is only for when you want something to be talked about outside of the presence of the jury, and since there is no jury here, there's no reason to have a sidebar. Examinations are going to take hours, if not days, especially a witness as important as this private investigator. You've got to lay really, really specific foundation, which they haven't done here. So it wouldn't be surprising for the attorney to ask for a short recess before starting into their cross-examination of one of the most important witnesses of the entire trial.
What the hell are you doing? I'm kicking my ass. Do you mind?
Fletcher Reed is really going to need a new suit after this. If you need a new suit, check out the links in the description below. It's where I get all my suits and it helps out the channel.
Order! Order! Under the circumstances, I have no choice but to recess this case until 9 a.m. tomorrow morning. Unless, of course, you feel you can still proceed.
So, in reality, if someone really had been beaten up in the middle of trial, everything would stop. There would basically be a manhunt going on in this courthouse. The judge would never just ask if Fletcher Reed was ready to continue because there would be police swarming all over the place. Maybe the SWAT team was called in. There's going to be an investigation and they need to find this horrible person that presumably beat the hell out of Fletcher Reed. So this trial would not continue on the same day at all. It would stop immediately.
Hello?
So you actually have to be really careful when you bring cell phones into court. Some courthouses allow it, but others, like the federal courthouse in Virginia that proceeded over the Manafort case, don't allow any cell phones whatsoever. And they don't even have cubbies or safes to lock up your cell phone when you get there. So if you arrive in court, you're forced to get rid of your cell phone or find some other place off premises to store it. God help you if your cell phone goes off and the judge hears it. I have seen people expelled from court specifically for violating a rule like that. Judges can be really, really persnickety when it comes to electronic devices and things going off in their courtroom. So you got to be very careful.
Respondent calls Kenneth Falk.
I think that's right to call them the respondent. This is not a situation where you'd have plaintiff and defendant. I think it would be claimant and respondent, which is a nice little touch to get that terminology right. I think that's correct. Don't do it. Don't enter the well.
Do you know my client, Samantha Cole?
Yes.
Okay, good question. Establish it. Open-ended. Good job.
Isn't it true that your relationship with my client is entirely platonic? I object, Your Honor!
To yourself?
Yeah. But I would like to rephrase the question.
That was actually a good objection. He asked a leading question of this witness, and if he hadn't objected, the other attorney should have, because you're not allowed to lead your own witness. This is direct examination. All your questions have to be open-ended. So when he asked, isn't it true that you've never blah, 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 that was improper. That question implied only one answer, and that's exactly what you're not allowed to do on direct examination. So good objection and good striking of the record.
You had sex with her every time you met, didn't you? Didn't you? Liar!
He's badgering the witness.
It's his witness.
You slammed her, you
Still can't badger the
gave
witness.
her dog a sausage. You stuffed her like a Thanksgiving turkey.
All right, it's true, okay? I humped her brains out. There, now you happy?
No further questions.
So I probably don't need to tell you that there's all kinds of things that are wrong here. Number one, he's asking tons of leading questions. He is badgering the witness like crazy. He is asking argumentative questions. Just because he has called this witness doesn't mean that he is allowed to engage in that kind of behavior. That's totally unprofessional. And it's really probably a violation of your duty of loyalty to your client. So despite him being honest, he is still breaking his ethical rules to his client. So what he really needs to do is just shut up and not say anything. That way he can both tell the truth and also uphold his ethical obligations to his client.
No questions.
Yeah, exactly right. When you don't need to gild the lily, you don't need to get anything else out of the witness, you do not ask any questions, you do not ask any follow-up, you just let the record remain where it is so that the other side doesn't have an opportunity to have a rebuttal or to do damage control of what they've already done. You just let sleeping dogs lie and you move on. So great job by this other attorney.
Is this a copy of your driver's license?
Not allowed to enter the well like that. The bailiff will tackle you.
And it says here you were born in 1964, but that's not true either, is it? Is it?
No.
Can you tell me what it says here on your birth certificate under date of birth?
Your Honor, I object. What does this have to do with anything?
Overruled.
None of this stuff is in evidence yet. You have to add this to the evidence before you're allowed to talk about it. You just need to establish that a material fact is more or less likely to be true based on the presence of this evidence or testimony. So that's a very, very low bar. So in reality, if the judge didn't really know where Fletcher Reed was going with this argument, then what the judge would do is ask Fletcher Reed to make a proffer. He would not just say, I have no idea what's going to happen, so I'm just going to allow this evidence to come in. The idea that you're going to sandbag everyone, including the judge and the other side, it rarely happens in real life. There's so much briefing and there's so much back and forth that you have an idea of what arguments are going to be made ahead of time. It's not just sprung on you and your client like it is in this movie.
And the truth shall set you free. My client lied about her age. She was only 17 when she got married, which makes her a minor. And in the great state of California, no minor can enter into any legal contract without parental consent, including
Prenuptial agreement.
prenuptial agreements. This contract is void. The fact
Voidable.
that my client has been ridden more than Seattle Slew is irrelevant.
Sort of.
Standard community property applies, and she is entitled to half of the marital assets.
Maybe.
$11.395 million. Jordan fades back. Swoosh. And that's the game.
That is not the game.
Nothing further, Your Honor.
All right, let's talk about marriage law. Last time I covered this scene just in isolation, I pointed out that in California, a minor can enter into a contract when they are still a minor. That contract becomes voidable at the option of the minor, who can then ratify or disclaim that contract when they get to the age of majority, which is the age of 18 in California. So as a technical matter, the contract is not void ab initio. In other words, it's not void from the very beginning of the contract. It is voidable at the option of the minor. But that is not the end of the question. Now it's time to think like a lawyer. So, the respondent argues that the prenuptial agreement is voidable, and she's exercising her option to void it. All right, so what does the other side say? Well, this is not the end of the game. This is actually the very beginning. What the husband would probably argue is a couple of things. Number one, a contract can be ratified without an express, or in other words, the actual language of ratification. You can ratify a contract by your conduct. So the husband would argue that for the last 13 years, this woman has been in the marriage, has received all the benefits of the marriage, and therefore has ratified the prenuptial agreement that she entered into when she was a minor. Furthermore, I think the husband would also argue that the defense of fraud applies. This woman, without notifying the husband or fiance at that time, fraudulently stated that she was of the age to enter into a marriage and a marriage contract. So she committed a fraud on the marriage and on the husband. So he would have the burden to establish that a fraud was committed, and that is a defense to the lack of contract formation that she's arguing. I think he would be likely to win that defense, that affirmative defense. Now, the last time I covered this specific scene, a lot of astute viewers pointed out that, well, if the prenuptial agreement is void, then doesn't that mean that the entire marriage is void from the very beginning? Because the same fraud that precludes the prenuptial agreement from being effective would prevent the marriage itself from being effective. Well, that is a very, very interesting question, but that probably doesn't change the result. And here's why. In California, there's no such thing as common law marriage, but what there is something called a Marvin claim. You might have heard of this as palimony. In other words, just because you are able to show that a marriage is invalid, there is still a claim to be made for essentially exactly the same rights you would have if you had entered into a marriage. And the Marvin claim dates back to, I believe it's the 70s. It's named after the actor Lee Marvin, who had a 7-year relationship with a woman, and they didn't get married. But the court found that even in the absence of a marriage, that the equities required some division of assets along the lines of what would be given under a marriage. I think the equities in this particular case show that there is something that's like a marriage, and in that circumstance, the marriage rules would kick in, and you would still need to decide how those marital assets are divided up. California is a community property state. It is also a no-fault divorce state, which means that in general, it doesn't matter who has engaged in adultery. Either party is allowed to exit the marriage whenever they want, and if there is no prenuptial agreement, then community property applies, and there's more or less an even division of those assets that exist in the marital form. But to tie this all together, I think all the equities go to the husband, and that's something that courts really do take a look at. Even if you have good arguments on either side and there's no clear answer, the courts will look to the equities. And here, the wife has committed a fraud on the marriage. She's the one that committed the adultery in violation of the prenuptial agreement. And I think that the court is likely to take all of that into consideration, probably find that she has ratified the contract or that the affirmative defense of fraud applies. I think the husband probably wins here. But if you disagree, if there are any family law lawyers in the audience, let me know in the comments below. I would love to continue this discussion. And by the way, if this makes your head spin, it's you and me both. These are the kinds of gray areas that we get into in the law all the time. And that's why you often need to hire a lawyer to handle these kinds of things, because it gets really, really messy.
In light of this new evidence, the court must rule in favor of Mrs. Cole. She is hereby awarded half the marital assets.
Again, the judge would never just blurt out in the middle of the trial proceedings that one side has won as an entitled to whatever it is that they're asking for. Not all the witnesses have been called. The parties haven't conducted their closing arguments. They haven't filed their post-trial briefs. They haven't made their post-trial motions. There are a million things that need to happen between now and when the judge renders his final verdict, including giving a tentative decision and allowing the parties to talk about that final decision, probably calling for another settlement conference. No way would the judge ever just bang his gavel and say, "You win, respondent." Not gonna happen.
What?
If I get sole custody of the kids, that's another 10 grand in child support payments.
You just won $11 million!
Hey, I'm the victim here. You said it yourself. Now I'm gonna hit him where it hurts.
But you said he was a good father.
So?
Well, Mr. Reed, do we have an agreement on custody or not?
I think here Fletcher Reed needs to follow the wishes of his client and reject the settlement offer, although this would again happen in settlement negotiations outside of right in front of the judge after having handed down a verdict in this case. But if he finds himself ethically unable to make the argument that she wants to make, then he can withdraw from counsel. He can talk about irreconcilable differences between him and his client and make a motion to withdraw, as her first divorce attorney has already done in this case. She can she's not in a bad spot. She can get another counselor to help with this post-trial briefing and this post-trial custody dispute. So it wouldn't really be much prejudice to her.
Why should you be any different?
Bailiff, take him away.
This man is a good boy.
I don't think the judge has the power to issue a contempt ruling when court's not in session. This is after the trial has happened. I'm not sure he has that power.
I'm Jose Canseco! I'm Jose Canseco!
Now it's time to give Liar Liar a grade for legal realism. Now, there's a lot going against it. Unrealistic dialogue, supernatural elements, totally unrealistic trial timeline. But I have to admit, it was a ton of fun to try and untangle this legal web involving the prenup and a minor entering into a contract. Good job by the writers. So I give Liar Liar the benefit of the doubt, and I give it another B+. Not bad. Good job, guys. Do you agree with that grade? Leave your objections in the comments below and let me know what I should review next. In the meantime, check out this playlist that includes all of my prior reactions, including Suits, Better Call Saul, and tons more. So click on the playlist and I'll see you in court.